Welcome back, everyone. Thanks for sticking with us. We still have lots of great stuff coming on, especially this next panel, which is the first of our spotlights today. And the spotlight today is national security. And wow, are you going to be impressed about who we have here? First off, we have moderating the discussion is Luke Dembosky. And Luke's co-chair of the data strategy and security practice at Debevoise in Plimpton. What makes Luke a cyber expert is not just his extraordinary legal and technical expertise, which even led to his selection to serve as a member of the New York Governor's Cybersecurity Advisory Board, but it's also that Luke has the kind of government experience that is like no one else that I've ever known, no one else that you'll ever hear from today. First, he was DOJ's resident legal advisor at the U.S. Embassy in Moscow, something only a half dozen or so DOJ attorneys have ever done. Second, he was deputy chief for litigation at DOJ's Computer Crime and Intellectual Property section. And that's the specialized group in DOJ that deals with cyber, where he oversaw DOJ's data breach response efforts at places like Target, Sony, Home Depot, Anthem, the OPM data breach, and lots more. And third, as Deputy Assistant Attorney General at DOJ in the National Security Division, focusing on nation-state threats. No, Luke Dembosky is not the Michael Jordan of IR. Michael Jordan is the Luke Dembosky of the NBA. And if Luke had a theme song, it would be That's Life by Frank Sinatra, because as a lawyer, boy, has Luke lived it. And he's really only just begun. So welcome, Luke.
Wow, John, no pressure.
Well, there's no pressure on you because all the pressure is on our next speaker, Eun-Young Choi, the Deputy Assistant Attorney General of the National Security Division of the U.S. Department of Justice. She is perhaps the second most important prosecutor in all of the U.S. Department of Justice, maybe in all of the world. It's the same. It's very similar to the same that Luke had. Eun-Young, or EYC, as her former SDNY colleagues call her, is at her essence a cyber lawyer because she previously served as the CHIP, the Computer Hacking and Intellectual Property section in the Southern District of New York. And that's the designation of attorney in a particular U.S. attorney's office who focuses primarily on technology-related issues. And she worked there for 9 years, making her bones on some of the most important criminal prosecutions in the world. She was also the first director of the National Cryptocurrency Enforcement Team. And my favorite quote from her back then was this, quote, "We are seeing cryptocurrency and digital assets really touch every aspect of criminal activity we investigate. By its very nature, the technology is built in order to not rely on intermediaries, cross-border transactions that are immutable and irreversible. Law enforcement can freeze conventional transactions, but they can't do that with digital asset transactions." That's no spin. That's telling it like it is, which is why EYC is so special. And because she is the last word on cyber prosecutions, her message has got to be above all else, don't do the crime if you can't do the time, which makes the theme song from Beretta the ideal theme song for EYC. So welcome to you both. I can't wait to listen to this. Take it from here, Luke. Thank you. And thank you, EYC, for being here. We really, really appreciate it.
Of course. Thank you for having me.
Thank you, John. Well, Eun-Young, we'll dive right in. I've got a few questions to kick us off, and we'll also take some Q&A, time permitting, from the audience. I'll do my best to keep an eye on the Q&A coming in here as well. Maybe we could start with a little bit of a threat update. A lot of us spend our time trying to advise, for example, companies on how to prepare for and respond to cutting-edge threats. And it seems like an increasing number of them are facing national security level threats. And I wonder if there's any particular trends or developments that you want to call out on the threat side.
Thanks, Luke. That's an excellent question. I think it's an important one to give context to the rest of the conversation I look forward to having with you today. In the context of cybersecurity, you don't really need access to the classified intelligence to understand the multidimensional ways in which cyber threats are threatening our national security. And that's both in terms of nation state actors as well as transnational criminal actors. So if I could start a minute on the national security side, because I think it's important to highlight the threat picture on that side. The adversarial countries are those that are well known to us, the big four. That's China, Russia, Iran, and North Korea. And I think the best way to sort of summarize those threats is in two ways. One is just to talk about the work that we're doing, and I would say the vast majority of the work that we're focused on is on in the national security space is on those big four, and that's also evident from the public announcements of some of the cases that we've done in recent months, including on the disruption side and also in announcing of charges. But separate and apart from that, I think the IC's annual threat assessment is always a good indicator of what their perceptions across the intelligence community is about these nation-state threats. And from this year's annual threat assessment from February, it notes that China remains the most active and persistent cyber threat to the United States government, private sector, and critical infrastructure networks, including cyber operations intended to preposition cyber attacks against infrastructure and to enable disrupting communications between the United States and Asia, especially if there were ever the unfortunate circumstance of a major conflict between that Beijing perceives may be imminent between Beijing and others. It also notes a specific emphasis by China on ensuring that it becomes a world science and technology superpower and to use this technological superiority for economic, political, and military gain. And one of the ways they're trying to fast track their superpower status in science and technology is not only through investments, but also intellectual property acquisition and theft, as well as cyber operations and illicit procurements of these types of technologies. So these are all areas that we are specifically focused on when it comes to China. With regard to Russia, obviously Russia is continuing to impose a enduring global cyber threat, even though they're focused presently and prioritizing their cyber operations as it relates to the Ukrainian war. That's because, in part, according to the IC, Moscow views cyber disruptions as a foreign policy lever to shape other countries' decisions and continuously refines and employs its espionage, influence, and attack capabilities against a variety of targets, including our critical infrastructure and that of our allies. Similarly, Iran's growing expertise and willingness to conduct aggressive cyber operations makes it a major threat to our security and of the United States and also allied and partner networks and data. And finally, North Korea's cyber program will continue to pose a sophisticated and agile espionage, cybercrime, and attack threat. In particular, we're seeing it in two areas. One most significantly is their attacks on efforts to do revenue generation through the targeting of cryptocurrency platforms, but also through something that may be of more import to your audience, or the audience here today, which is their use of their IT worker programs, where they'll pretend to be freelance workers based in the US, based in Silicon Valley, and infiltrating US companies through that notion by tricking US companies into thinking that they're American IT workers that they're hiring on the other end of the computer. That's not even to sort of mention all the transnational criminal threats that we're dealing with, including ransomware gangs and their affiliates who are exploiting the targets of opportunity, which will sometimes have national security implications depending on the victim company. I mean, the good news of all of this is even though our adversaries are more brazen, they're more sophisticated, and they're more persistent and aggressive in their attempts to infiltrate our infrastructure and our networks, the good news is that the way in which that we can ensure that we're hardening our own defenses are universal regardless of what the threat actor is. Those methods are really targeting things like how do they access initially the networks of the victim companies and entities that they're interested in. And so making sure that you have hardened your own network infrastructure is really a solution to all of those threats from an individual company's perspective.
That's a great point that defenses are essentially largely the same fundamentals, whether you're facing cyber criminals or facing a nation state. But what about on the response side for the government? So a lot of, for example, our clients are used to interfacing with the FBI or other law enforcement on cyber crime issues. If it really is a nation state attack, how does it change for them in how the government works with them? Would there be, a broader range of agencies involved? Is there more likelihood to compel evidence, from the victim on the part of the government in a nation state attack?
That's an excellent question. Look, I think the first point I want to make is that all of us who work in law enforcement at the department and at the FBI understand that I want everyone to understand that this is a very victim-centric program. We only choose to do these jobs because we really believe in the mission of keeping the American public safe and keeping our national security intact. And we understand that when we're in the aftermath of an incident of any significance, the victim company isn't wanting to necessarily go to law enforcement first and foremost. They're trying to ensure that they're remediating and containing the incident as best they can, and making sure that they're making the hard decisions that sometimes they have to do about how best to respond, including, for instance, in a ransomware attack, the hard question of whether or not to pay a ransom demand to get access to their systems. So as a general principle, I want to just highlight that for companies who are coming to law enforcement in the first instance to report the incident asking for assistance, whether the actor is a transnational criminal actor or a nation state threat actor, should have very little or no impact to how the government interacts with the victim for a few reasons. The first is that the government writ large has really taken to treating cyber as a team sport. In fact, because each of the agencies have their own authorities and ways in which they can help bring their tools to the cyber fight. So in every case of any significance, we're really working hand in hand across multiple federal and foreign partners even. And that's really important for our ability to disrupt nation state and cyber criminal threats of all sorts. So that coordination is built into the mission. When it comes to nation states especially, there are many agencies, including across the IC, who will be monitoring significant APT groups and their activities over the course of time. But that just means that there's the muscle memory there to ensure there's coordination. So when you, as a victim company, come to the FBI, for instance, because they're dual-hatted in their law enforcement, their IC position, and also because they're constantly working with CISA to ensure that we are doing both threat response, but also asset response in the case of these incidents, there really shouldn't be a problem or a difference of a reaction from the victim company's perspective. Let us make sure that we're coordinating well. That's not your job. Your job is to make sure that you are protecting your networks and trying to remediate as best you can. On the question of evidence production, look, I think sometimes there is, again, a sort of a misconception of the type of information that we'll need at time zero when an incident occurs. And I think I think that this has been dispelled over the years, but oftentimes when I would come to speak with the private sector, there was a fear that if they were to call law enforcement in the event of a incident, that law enforcement would want to somehow gain access to their sensitive data or, ask to have control over the systems. That is not usually, that is not how the FBI operates. We don't really want to have all that data, quite frankly. What we're looking for are indicators of compromise, TTPs, sort of the technical aspects, perhaps a sample of malware at the very beginning to understand what threat actor it is and sort of follow the digital fingerprints to determine whether or not there's other infrastructure that we can illuminate through our criminal authorities to help identify really other victims and opportunities to disrupt this activity. And so we're really looking for a very narrow set of non-content based data in the first instance, understanding again that victims are very busy and focused on ensuring that they're shoring up their own networks in the event of an incident. So I would say that it's very rare for us to have to get to a position where we would have to subpoena a company. In most instances, when the company is first interacting with law enforcement, because of the targeted and narrow requests that they'll make at the beginning, most companies have been very forthcoming with that information. It's really important to us so that, again, we can go and follow the investigative steps that we need to take, take and collect evidence and identify and illuminate the entire network of activity for these actors.
It does seem like the national security apparatus and NSD have been more willing to take things out of the classified space and warn victims to do read-ins if necessary. If people don't have a clearance. Am I right about that? Is that your impression?
I think that's right. I think that's a reflection of the understanding, sort of what I had alluded to before, that we're never going to be able to do all the criminal investigations and prosecutions to eliminate the cyber threat, right? That can't be the first tool in the toolbox. What really needs to happen is ensuring that the private sector network defenders are well equipped to deal with threats that we are seeing, because resilience and defense is always going to be the more effective means to ensure that we're minimizing and containing the threat posed by these cyber actors. And so over the course of at least my career, I've seen that the initial reluctance perhaps to declassify information has been widely reversed. And we're really looking to ensure that we are issuing information, whether it be specific briefings to companies that we've identified through a variety of our law enforcement or IC authorities as potential victims, and sort of explaining that they're being targeted, doing those types of warnings, or more generally to the public, we're issuing cybersecurity advisories with technical information about the threat actors that we're seeing. I think those types of interactions with the private sector are really designed to ensure that we are using the information that we're gleaning from our authorities and from victim reporting, quite frankly, which is a huge part of our aperture when it comes to understanding the complete threat profile, and ensuring that we are then turning that around and making that into useful, actionable information that can be of help to the private sector.
So we have some questions coming in, but I want to ask you just one more quickly before we turn to some of the questions from the audience. But there's a lot of talk about the SEC cyber rule for issuers. Other rules are coming for investment advisors, broker dealers. You've spoken recently about the national security exception, and I just wondered, is the department already getting requests? Have you received any requests for the national security exception to delay an 8K? And whether you have or not, is there any sort of, if you had to give one nugget of guidance for people on how to think about that, what would it be?
That's a great question, Luke. I would say with regard to Form 8K item 1.05, that rule went into effect that requires reporting within 4 days of a determination by a registrant that there is a cybersecurity incident that is in fact material. It requires certain disclosures to occur, and there is this exception that's baked into the rule that allows for the disclosure to be delayed if the AG determines that the disclosure would pose a substantial risk to national security or public safety for a certain period of time, subject to another period of time of renewal. But since that rule went into effect, or taking a step back, when that rule went into effect in mid-December, we, at that time or right before, we released guidance about how companies could make requests for such delay and the type of analysis that we would undertake to determine whether or not the delay would be granted. And that guidance is available on FBI's website. It's easy if you just look it up on any search engine. But I will note that since the rule has gone into effect in mid-December, although over a dozen companies to our count have disclosed material cybersecurity incidents, there have been 0 requests of the department to invoke a delay in disclosure. And that fact to us suggests that companies are analyzing the rule in a manner that's similar to what our guidance suggests, namely that a reporting delay should only be sought in pretty significant break the glass scenarios that would not sort of apply in most breach incidents. In the guidance, we gave some examples of some situations or scenarios in which we thought that the delay may be invoked, including where a victim company has identified a 0-day delay or a software vulnerability where there was no clear remediation or mitigation available, or where the disclosure might lead to additional victims, or where the public company is conducting remediation for critical infrastructure and somehow the disclosure would undermine those efforts. But in any event, I think if a company is making an assessment about materiality after an incident and they're contemplating whether or not to make such a request, we would just encourage victims to come to the FBI and to us early, even before the materiality assessment has been made, which is really what starts the clock in terms of making sure that the disclosure is done, so that we can ensure that we have the most complete picture possible, and we're having that discussion with the victim company to assess early whether or not the exception could apply. I think it's very helpful to us to be able to have those conversations before the 4-day window starts, and I think it could be helpful as well to the victims so that they understand what are the criteria and what are the questions that will be relevant in our assessment.
That's great. We have an audience question about how you work with the Five Eyes Coalition to address state-sponsored threats.
Well, I think there are a lot of different ways that we work with the Five Eyes. Obviously, there are Five Eye partners because they're our closest allies, and oftentimes we're seeing the same geopolitical threats against the United States as they are in their own countries. I think a good recent example of that is our action in the unsealing of an indictment a few weeks ago in the Eastern District of New York, which charged 7 PRC nationals who were a member of AB 31 with engaging in a 14-year cyber campaign targeting U.S. and foreign businesses, political officials, and critics of the PRC. I would say for almost all of the APT groups, there is information sharing that's being done at the IC partners, and we are working very closely with our foreign law enforcement partners to see when we have an investigation that is active on an actor threat, such as APT 31, we can pair our sort of public announcement explaining the nature of the types of targeting that the entity that the group was engaged in, the harm that they had done, and the sort of rationale behind why, or the reasons behind why they were doing that, as best as we can glean from what their activity was, and pair that with other disruptive actions that our Five Eyes are taking, including illuminating making public statements, illuminating what is going on from their perspective about the attacks of those actor sets in their own jurisdiction. And doing so sort of gives you a more holistic understanding of what the motivations might be for any particular group, and also sort of a more systemic and fuller picture about what all of the different types of activities they are. But we're learning. I mean, it's one of those situations where in every one of these incidents, we're always constantly looking to see if there are ways to pair up with our foreign partners, even if they're not in publicly facing activity, because again, we're facing the same threats. We want a more holistic picture. We want to understand what sort of TGPs and IOCs they're seeing, so that we can ensure that we are looking for the same means and methods within our own investigations, and that we're working in a mutually beneficial manner to strengthen everyone's knowledge about these actors and ensure that we're, again, providing actionable intelligence to private sector entities that they can use to then strengthen their own defenses.
And one of the questions that our team had as we were preparing Young is, to what extent have we as, rule of law societies focused too much on privacy regulation and disclosure? Or have we neglected cyber and threat indicator sharing and national security risks at the expense of other types of regulation, or do you see it possible to reconcile these?
I think they are reconcilable. So let's just talk. I don't know if you have anything in particular in mind, but I think generally let's just talk, for example, about privacy when it comes to U.S. persons data. I mean, obviously, individual Americans may feel very strongly about ensuring that the data that they are sharing or using sort of to interface with the internet, which is sort of how we do every aspect of our life at this point, is protected by the entities that they share it with. But on the flip side, not just the reason why that's important to protect U.S. data is not just because of the privacy rights, but it's also because that information can be used to threaten our national security. We're seeing it in a variety of different ways. Obviously, certain nation-state actors that are looking to, for instance, conduct surveillance or espionage activities and are targeting particular individuals within our jurisdiction. That information is very valuable to them to understand sort of what their life patterns are, understand more about who might be close to them that may be vulnerable to outreach from an intelligence officer. That type of information can be of use. And separate and apart from that, there could be more wide-scale influence campaigns or the use of AI that can be driven and sort of supercharged by the use of U.S. data. That's why I think that they're not completely separate. There may be different values that underpin why you would want those regulations in place, but the underlying threat can be sort of solved, or those two threats, the two interests, the privacy interest and the national security interest, can be both aligned in sort of finding solutions that be mutually beneficial for both interests. So I don't think that they are necessarily mutually exclusive, and I think there have been a lot of learning sort of from past lessons learned in the course of cyber and data regulation. I think that the public writ large is much more attuned to and understands the threat of data and why we need to protect that data in a way that was not the case when I started this job. Like, it was not, I don't think people understood, for instance, the reach of social media companies back when I started the department. And I think over time, it's become more evident to policymakers and to the public writ large. So I think the time has come for us to have a more holistic approach towards regulation, and I think policymakers have both of those interests in mind.
You mentioned AI, and I'm wondering what you think the future of this space looks like. We've got AI, deepfake technology, you also referenced. Quantum computing is, posing a threat to the way we authenticate, traditional password use and other innovations. I mean, do these inherently favor attackers, or can defenders leverage these as well and perhaps even either level the playing field or gain even an edge from these innovations? I wonder what you see happening in the future trend-wise.
I think that's the million-dollar question when it comes to AI or really any new disruptive technology. In any situation in which, technology is just a tool in order for us to, from my perspective, in order for any actor to further endeavor what they were trying to do in the first instance, right? So the real question is whether or not we can ensure that we're harnessing the positive benefits of the technology within the contours of our cybersecurity space while minimizing the risks that are attendant to bad actors exploiting those technologies as well. Look, generative AI is going to enable cyber actors to develop increasingly powerful and sophisticated means to do what they're already doing to make customizable cyber attacks and scalable cyber capabilities. We're seeing that in the context already of efforts by bad actors to gain access to networks through spear phishing and other means. We're also seeing synthetic voice and video or deep fake sort of pervasively in the social media aspects, and those can have an impact, not just hypothetically, but can actually impact elections. I mean, it's something that we're even seeing in the Indian elections through open source reporting, where Prime Minister Modi has an AI generated video that has a personal outreach to each individual that they target through the use of AI, and that's just ahead of his own elections. So the question is whether or not network defenders can also harness AI and machine learning, and I'm optimistic that they can. They could use AI for harnessing, proactive threat intelligence, automating tasks to make it quicker to respond in the instance of threats being detected, and generally enhance their capabilities to protect and prevent and defend against cyber attacks of all sorts. So I think the question is really resourcing, whether or not the private sector is really going to be focused on that, whether or not the government is also going to ensure that there are guardrails and cybersecurity standards that can be universal, which is obviously something that the federal government has been working on, but also to determine whether or not we're sort of ensuring that we're at least meeting the task of having the capabilities to detect when AI is being used by bad actors and being able to harness those tools to defend against as well.
Yeah, one more question, maybe we'll end on this. And I confess that I sort of, the premise of the question is at odds with my own experience, and I think with yours, which is that law enforcement interaction has been a one-way street. Victims give information and don't get anything back, and what's being done to change that. I'll just say my own experience in recent years with the FBI and Secret Service and others is quite the opposite. When our team shares indicators, we get quite a bit back. It does help for us to share because that tells the government a little bit about the threat actor, and we end up getting a net gain in information back in a lot of cases. But how do you see that, and what is the department doing to sort of change the perception there?
So that's an excellent question. It is, I think, again, one that was a criticism of how we did business perhaps a decade ago, but I think has definitely changed. In my own interactions and meetings and communications across the interagency in this question, that we're united. We need to be in a position where we're forward leaning on information sharing back to victim companies. Because again, what are we doing this for? It's not so that we can at some point potentially have charges, although that would be great, against a nation state actor who we probably will never get because they're located in a country or a jurisdiction where we can never extradite from. We want to make sure that we're protecting the American public. I think it is very crucial, and we have now enshrined this in our own cybersecurity strategies, both across the government, but also within the Department of Justice, that we're looking to have opportunities to ensure that we can disrupt an ongoing cyber threat, even if it means that the prosecution may be more difficult down the line. And that means sharing that information back to victim companies. If there's an opportunity, because we have access to a ransomware network servers to get keys and give them to victim companies, we will do that, even if it means ultimately the ransomware actors will know that we're in their systems. That is important to us because the only thing that we're doing this for is to ensure that victims are best situated to protect against the ongoing cyber threat. And I do think that the increase of joint cybersecurity advisories, the engagement that we've had with the private sector, both on the unclassified and classified level, the efforts that I know the Bureau has undertaken, for instance, to ensure that there is a model for victim outreach in every time that we can identify a new one via law enforcement or classified means, we're doing that because we understand how important that is, and that is, again, the best strategy that we have to ensure that we're taking a whole of society approach really to the cybersecurity threat.